Hi friends. So today Monday, and I am trying to do Indian Penal Code today. So this is Chapter 1, Introduction, Section 1 to 5. So the Indian Penal Code 1860 came into force on. So the date is 6th October 1860. So the Indian Penal Code 1860, of course, the year you can see, and this is 6th October. So there were two 1860 in the choices. So 6th October 1860, Indian Penal Code came into force. To which of the following is Indian Penal Code not applicable? So this is to the state of Jammu and Kashmir. It is not applicable. Which section of Indian Penal Code confers extraterritorial operation? Section 3 and 4. Okay. So which section of Indian Penal Code confers extraterritorial operations? It's section 3 and 4. Which of the following statements about Indian Penal Code is true? So that is, the Indian Penal Code applies to every person in any part of India for every act or omission contrary to the provisions of the code. The Indian Penal Code applies to any offence committed by any citizen of India within and beyond India. Every such act committed outside India which is committed in India would be punishable under the Indian Penal Code. So it applies to every person in any part of India for every act or omission contrary to the provisions of the code. It applies to any offence committed by a citizen of India within or beyond. Okay, so it is committed outside India which is committed in India would be punishable under Indian Penal Code. So it is to be three conditions to be taken into account. So all of the above as per the choices given. So question 5th, a national of Pakistan fires from other side of the border and a person within Indian border is killed. The relative friends and other Indians rush and drag the Pakistani to border Indian police station. Can the Indian court try the accused for murder? Yes, so they can. A Spanish citizen who was residing in Paris instigated a commission of an offence which in consequence was committed in India. He is liable as the offence was committed in India. Okay. A who is a citizen of India commits a murder in England. Of course he is liable. For me, I would say he is a citizen of India. He is found in Indore and arrested accordingly. Where can A be tried? So question 7. At Indore where he was found. So he can be tried in Indore, and he is part of this. He is a citizen of India, so he is part of IPC 1860. Under which of the following situations would the Indian courts have jurisdiction? Okay, the crime committed by an Indian in a foreign country, crime committed by a foreigner in India, crime committed by a person on an Indian ship. So all 1, 2 and 3. A foreigner stabbed B, another foreigner, in a foreign vessel on a high sea. Both A and B were brought to Bombay for treatment where B died. A is also available in Bombay. Which one of the following proposition is correct in respect of the applicability of IPC to trial of A? Okay, this is A, which says as both the disease and the accused belongs to foreign countries and the occurrence of offence has taken place on high seas, IPC is not applicable to A and hence he cannot be prosecuted in India, which I also thought the same, because since both were outsiders, both the things happened at outside seas, so it is not applicable in IPC. Okay, chapter 2, general explanation. In Indian Penal Code, the pronouns he and its derivatives were used for any person, whether male or female. It is for every person. Okay, under Indian Penal Code, a person is defined as including any company or a body of persons, whether incorporated or not. Including any company or body of persons, whether incorporated or not. Okay, so under Indian Penal Code, a person is defined as including any body or person, whether incorporated or not. In context of Indian Penal Code, 1860 India means? It means the territory of India excluding the states of Jammu and Kashmir. Okay, in which section of IPC public servant is defined? Section 21 September. Who, according to section 21 of Indian Penal Code 1860, is not a public servant? D. That is an advocate who practices law in a court of justice. He is not a public servant. Not a public servant. Who among the following is not a public servant? Okay. C. That is surveyor of an insurance company. He is also not a public servant. Okay. It was held that a chief minister or a minister is in the pay of the government and therefore public servant within the meaning of section 21 subsection 2 of IPC in case of, so this is Karunanidhi versus Union of India. Okay. Which of the following is not a public servant within the meaning of section 21 of the code? 17D. That is examiner of the university. One of the following is not a public servant. 18. That is secretary of a cooperative society. Okay. Movable property under IPC is defined in section 22. The definition of movable property under section 22 of Indian Penal Code 1860 excludes all of the above. That is land, things attached to the earth, things permanently fastened to anything which is attached to the earth. So this is not not an example of movable property. I have learned this all thing before, I think in C or BCom. Wrongful gains and wrongful loss have been defined under Indian Penal Code in section 21 section 23 in section 23. Okay. Consider the following statements. Anything is said to have been done dishonestly if it has been done with intention to cause wrongful loss to any person and a wrongful gain to another person, can cause injury to any person. Which of the statement given above is or are correct? Question 22A. So can cause wrongful loss to any person, wrongful gain to any person. This is not correct. This is correct, sorry. Whoever does anything with the intention of causing wrongful gain to one person and wrongful loss to another is said to do that thing dishonestly. The term dishonestly as defined under section 24 of IPC implies an act done with the intention of causing wrongful gain to one person or wrongful loss to another. Section 34 of Indian Penal Code deals with common intention. Section 34 of Indian Penal Code recognizes one of the following principles of criminal jurisprudence. Question 26, principle of joint liability. Section 34 of Indian Penal Code 1860 is the rule of evidence. Okay. When a criminal act is done by several persons, each of such person is liable for that act in the same manner as if it were done by him alone, if it is done in furtherance of common intention. Okay. In cases of common intention, which of the following statement holds true? In a gang rape cases, it is not necessary for common intention to be formed from the beginning. It can be developed at last minute before committing of the offense. Okay. In which of the following case the Privy Council made a distinction between common intention and a similar intention? Mehboob Shah versus King Emperor. The principles of common intention applies only when at least two persons involved. Under which of the following section of IPC the principle of joint criminal liability is applicable? Section 34. Which of the following is not a meaning of the expression common intention under section 34 of Indian Penal Code? The desire to commit a criminal act without any contemplation of the consequence. What is the basic difference between section 34 and section 149 of IPC? Section 34 creates a principle of joint liability and does not create a specific offence. Section 149 creates a specific offence. Okay. Which of the following distinguishes Section 34 of IPC from Section 149 of, so this is the same thing, it creates joint liability and all that. I 149 creates substantive offence, whereas 34 does not create an offence. Okay, so it is 1, 2 and 3 all. It creates substantive, it requires common object. 149 it gives 5 or more persons, requires 5 or more persons. 34 does not create an offence, it requires common intention, it requires 2 or more persons. So all A. Which of the following statements regarding 34 and 149 of Indian Penal Code is correct? Question 36 ka C, that is section 34 enunciates a mere principle of liability and creates no offence, while 149 creates specific offence. A, B, C and D are charged for murder of E, but evidence proved that A, B, C and D along with 3 other jointly committed the offence. The court acquits A, B and C but convicts D. In the context of the above, which of the following statement is correct? Section, okay. The conviction is legally valid. Consider the following statements. Section 34 of IPC does not apply where five or more persons assembled where one killed A. The presence of any person who participated in the pre-arranged plan is not necessary at the time of actual commission of the crime. Privity of mind of all accused is an essential ingredient for commission of crime of these statements. So D. The difference between section 34 and 149 is that deals with group of liability, whereas deals with unlawful. Wrong. I think it is C. 39. Yep, it is C. Yes. So friends, this is IPC 1860. I've done 39 questions right now. I will be coming back, and till then, take care. Bye bye.